Honor Cheryl Luckoff on behalf of the plaintiff.
Right. Where are we on this one?
So, Your Honor, at the initial hearing, judgment was granted. There are bed bugs in the unit. It's a health hazard. And then Mr. Wazorek.
What happens when a tenant says he was muted out of his own eviction hearing, and the landlord says bed bugs are putting the entire building at risk? This case has everything: health hazards, alleged Zoom courtroom chaos, a default judgment, and a tenant fighting to be heard. One side says, we were denied entry. The other says, I never got a chance to speak. And now the judge is caught in the middle trying to figure out whether this is a cleanliness crisis or a procedural breakdown. Stick around, because what unfolds here isn't just about bed bugs, it's about due process, credibility, and whether a technical glitch could change everything.
Filed a motion to set aside the default judgment. And it's my understanding from speaking to my client this morning that Mr. Wazorek is planning to vacate the premises. So I'd like to clarify that.
Sure.
Say that again.
Are you hard?
Yeah, I'm hard of hearing. My hearing, I don't have
We have equipment if that will help you, sir.
yeah.
All right, let's get that.
I usually wear hearing aids, but my hearing aids are bad. Need to get a new set.
Okay. Let's see. That help you? Can you hear me?
Yeah.
Okay. You filed this motion to set aside the default, but the attorney was asking, or had been informed by her client, that you were planning on moving out.
I wouldn't plan on moving out. I just asked that if I plan on moving out, I would need more time, because I didn't have no time to set up anything. And I wasn't actually wanting to move out. But they were saying I needed to move out. I have made sure all the problems were taken care of in the apartment. I've had Section 8 come in there twice now and check it. Themselves, they haven't checked it at all. They had one guy come in, one maintenance man come in, bring up these charges about garbage being in my house. Well, the garbage wasn't garbage bags. Those were stuff that pots and pans and everything that we had cleaned up and put in that, because they told us we needed the cabinets all cleared out. So those weren't garbage bags. Those were all our dishes, food, canned goods, all that. I put them in the garbage bags to be able to clear the cabinets out so they could spray for cockroaches, which we never had to start with. And I had told them that, and they said they were gonna, this was on Friday.
Before you go on,
Okay.
because I'm dealing with your motion to set aside the default. Ms. Luckoff, were you present at the previous hearing?
Yes, I was present. I put the proofs on the record with a witness, Your Honor. And what we had put on the record was that on the second, my client's pest control was denied entry because he was not prepared. And then again, the day of court, they were denied entry. And so at that juncture, we did take testimony, and the court established that there was a health hazard, that there are bed bugs that weren't being treated. And that is why the judgment was entered and the immediate order of eviction, which was prayed for.
Let's pause right here, because this is critical. The plaintiff's attorney is laying the legal groundwork for why that default judgment happened in the first place. According to her, pest control was denied entry not once but twice, and testimony was already taken establishing a health hazard. In eviction law, especially when it involves something like bed bugs, courts move quickly because it's not just about one tenant, it's about the entire building. Bed bugs spread fast, and when the court hears health hazard, that dramatically raises the stakes. But here's the twist. The defendant claims he was present and trying to participate. So now we're not just debating cleanliness, we're questioning whether the process itself was fair. If a party is improperly muted in a virtual hearing, that could undermine the entire judgment. So I've got to ask you, if you were the judge, would you focus more on the health risk, or on whether the tenant got a full opportunity to be heard?
for in the complaint. So if you'd like me to argue the motion, I can certainly argue it. This has been a chronic problem. There's just a cleanliness issue, and bed bugs, obviously, I don't have to tell the court about the problem with bed bugs. So, I mean, we're looking for possession of the premises, Your Honor. But again, I can argue the merits of the motion as well, if you'd like.
Well, one thing that I'm a bit confused of is that in the defendant's motion, he's saying that, and as I look at the judgment, he's saying that he was there but defaulted.
He was there, but then if I remember correctly, I think he disappeared at one point. And we waited
No.
for, yes, because Your Honor, I actually went to a judge's meeting because we wanted to wait to give him time. I went to another Zoom judge's meeting, came back, and he still wasn't there, and that's when Judge Barr entered the judgment.
Your Honor, I was there, they muted me. It was over Zoom and they muted me. So they couldn't get me there because every time I kept saying, Your Honor, I'm here, Your Honor, I'm here, I'm here, I'm here, I'm here. And they just kept saying, you've been muted. And I never got to say a word.
Well, he actually did get to say a word because he did put proofs on as well. And then we ended up.
Well, can I ask if that's the case, why was this judgment by default?
Well, as best I can recollect, because he didn't come back. I think what happened, actually, Your Honor, I believe I had to, and it'd be interesting if we could pull up that transcript because I'm going by my memory here, but I may have needed to get my witness on. And so we took a break. I do remember having to get Wendy on, and then he wasn't there. So we took another break. That's when I went to the judge's meeting, which was at noon. So I think it was, but we did hear from him originally. It's not that he was never heard.
The first time I was heard, but then they came back. I called the court clerk, asked what was going on with this case. And she told me, well, they're going back in there. And well, I couldn't hear no judge say that they were coming back. And the witness they had, Wendy,
they were coming back.
They told me the court clerk told me that he was making a final decision, that I had to get back into Zoom and find out what was going on because, and that's when they couldn't hear me at all. I couldn't be heard at all. So when they brought Wendy in there, I tried to talk. I couldn't, it was totally muted. It was muted on their end, not my end. My son was right there listening. I had him on loudspeaker. He was there listening. He heard the whole thing. I didn't get a chance to say a word. The second time, and Wendy came on there, the assistant manager, and she kept talking, and I kept trying to object, and they couldn't even hear me at all. It was like I wasn't even there. It's like the speaker said, you've been muted. And I couldn't say a word.
Okay, this is where things get intense. The defendant is making a serious allegation that the court muted him during a critical portion of the hearing, preventing him from objecting to testimony. That's not a small claim. Due process, the right to be heard, is foundational in any courtroom, virtual or not. If he truly couldn't speak while evidence was being presented, that could be grounds to set aside the default judgment entirely. But here's what makes this complicated. The attorney recalls that he did testify earlier and that breaks were taken. Was it a misunderstanding, a technical glitch, or selective memory? And notice how the judge reacts, not dismissing him outright, but expressing concern. That tells you something. Judges take procedural fairness seriously. Because even if bed bugs are a legitimate issue, the court process itself has to be. Clean too, so what do you think, genuine tech failure? Or a last-minute strategy to avoid eviction?
But you're alleging what you're alleging, which would cause me a bit of concern, is that you were there and that the court muted you.
Exactly.
Okay. Here's what I'm going to do. Your February rent is paid.
Yes.
I'm going to adjourn this to March 1st, 2024 at 10 a.m. In the interim, I'm going to take a look at the video of what transpired.
Okay, I appreciate it.
And Your Honor, if I may, I mean, the issue here is, and I'm totally fine with everything you're saying. I'm not even placing an objection. I just want us all to be clear here because this is regarding other residents' health, due to bed bugs. So I want to put on the record here because as you know, I am transparent. They did go in last week. They did treat last week. They have to go back in again next week. So we're still asking for possession of the unit, but I want to make sure we can get back in to treat just to protect the other residents. So we'll come back. I have no problem with anything the court's doing. That's just, I wanted to put that on.
Okay.
The record.
I got
Yes, Your
you.
Honor, I've never had no objections.
Well, sir, hold on. All I'm saying is you need to let them in so that they can treat the premises. I just want to look at what happened because if something procedural happened where he was muted, then I've got a different problem than what I may have. All right.
Okay, yeah, because the one time they,
Sir, I'm not hearing what happened. I just need you to let them in so that.
yes, I've been doing it.
This hearing ends with a temporary pause, not a final victory for either side. The judge adjourns the case to review the Zoom recording, which is a smart procedural move. Why? Because if the tenant was muted improperly, the prior default judgment could be vulnerable. But at the same time, the court makes one thing crystal clear: pest control must be allowed access. Public health, especially involving bed bugs in a multi-unit property, is an optional dot, so where does this leave us? Legally, this case now hinges on two questions. Was there a legitimate health hazard justifying eviction? And was the tenant afforded full due process during the original hearing? One focuses on property conditions, the other on constitutional fairness. Both matter. Cases like this show how modern virtual hearings can introduce new procedural challenges and how quickly housing disputes can escalate when communication breaks down. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, especially whether you think this was a tech failure or something more. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And then we'll see you next.
Yes, Your Honor, I've been doing it. I've been letting
Right?
it in. Yes.
Thank you.